Welcome back to Enchanted Learning. It's me, Benasir Khalid. In the previous class, we were discussing about fundamental rights. We have not yet completed it. So, in today's class also, we will be discussing about fundamental rights. Hope you are all studying well. Past is a waste paper. Present is a newspaper. Future is a question paper. If you don't write clearly and correctly, your life will be a tissue paper. These are the famous quotes of Dr. APJ Abdul Kalam. In present, but should not worry about the past. You should not worry about the past. You should live in present and work hard as well as smartly to achieve your goal in future. That's what's mentioned in this quote. So now moving to the Article 20. Article 20. Article 20 deals with protection in respect of conviction for offences. Protection in respect of conviction for offences. That means Article 20 grants protection against arbitrary as well as excessive punishment to an accused person, whether he may be a citizen or foreigner or legal person like a company or a corporation. So according to Article 20, it grants protection against arbitrary or excessive punishment to an accused person. And it contains three provisions. This particular act contains this particular article contains three provisions. They are no ex post facto law, no double jeopardy, and no self-incrimination. So, no ex post facto law. That means no person shall be convicted of any offence except for violation of a law in force at the time of commission of the act. That means no ex post facto law means, for example, cigarette smoking is strictly prohibited in public areas. This particular law was enacted recently. But if a person had committed such an offence like smoking cigarette in a public area, before the enactment of this particular law, he may not be punished. He cannot be punished. So that person cannot be punished if he had done such a, or if he had committed such an offence before the enactment of the law, he can be punished. That is what mentioned in no ex post facto law. That is, no person shall be convicted of any offence except for violation of a law in force at the time of commission of the particular act. The second one is no double jeopardy. No double jeopardy means no person shall be prosecuted and punished for the same offence more than once. That is, no person shall be prosecuted and punished for the same offence more than once. That is, a person should not be punished for the same offence for more than once. That is what explained in no double jeopardy. Then no self-incrimination. That is, no self-incrimination means no person accused of any offence shall be compelled to be a witness against himself. That is, a person who is an accused person, a person who is accused person, he shall not be punished. Also, he shall not be punished. He shall not be compelled to be a victim. Shall be compelled. Sorry, no person shall be compelled to be a witness against himself. That is what explained in no self-incrimination. No person shall be compelled to witness against himself. These are the three provisions which are specified in Article 20. So, Article 20 means protection in respect of conviction for offences. This particular article contains three provisions, and the first one is no ex post facto law. That is what mentioned. It is a person should not be punished for a particular offence which he had committed before the enactment of a particular law. And no double jeopardy means a person should not be prosecuted or punished for the same offence more than once. And no self-incrimination. No self-incrimination means a person should not be compelled to be a victim against himself. A person means an accused person. He shall not be compelled to be a victim against himself. That is what mentioned in Article 20. Is it clear for you? Next, moving to Article 21. Next one, Article 21. Article 21 states that for protection of life and personal liberty. Article 21 deals with the protection of life and personal liberty. It assures protection to the life and personal liberty of a citizen as well as non-citizens. This particular right is available to both citizens as well as non-citizens. So that is about Article 21. It grants protection to the life and personal liberty of citizens as well as non-citizens. And we have to know that Article 20 and 21. These two articles cannot be suspended during the emergency. So during an emergency, the particular two articles, Article 20 and Article 21, cannot be suspended during an emergency. So that is according to national emergency. So during national emergency, certain articles, that is fundamental articles related to article, that is those articles which were mentioned Article 90. Those rights which you mentioned Article 19, those articles are suspended during a national emergency. Those articles are automatically suspended during a national emergency. That is as per Article 358. So Article 358 mentions during an emergency the following rights that's mentioned Article 19 are automatically suspended. And they are suspended temporarily, and those articles are automatically reinstalled by the emergency is emergency ends. So that's about Article 90. So Article 20 and 21 cannot be suspended during an emergency. That is the main thing we have to remember. Then according to Article 359, the President has is authority to suspend the fundamental rights during an emergency, and it is for a shorter period or as it is mentioned and that order, the President's order, should be approved by both House of the Parliament. That's all about emergency. So just remember, Article 20 and 21 cannot be suspended during an emergency. And Article 20 you understood, and Article 21 here grants protection to the life and personal liberty of the citizens as well as non-citizens. That's all about Article 20 and 21. And now you have to know Article 14 as well as Article 19 and 21. Article 14, 19 and 21 are considered as a golden triangle. So these articles, which are the articles which are considered to be which belongs to golden triangle, means it is Article 14, 19 and 21. Then next one is Article 21A. So next one is Article 21A. 21A. Article 21A deals with right to education. Right to education. Article 21A deals with the right to education. It declares that the state shall provide free and compulsory education to all children at the age of 6 to 14 years. And that means it's a responsibility of the state. Or state shall provide free and compulsory education to all children of age of 6 to 14 years. That is what mentioned in Article 21A. Article 21A means it deals right to education, where the state should provide free and compulsory education to children of age 6 to 14 years. And this act was came as per the Amendment Act of 2022. This act was introduced as per 86th Amendment Act of 2022. So, right to education, the Article 21A was introduced this particular article as per 86th Amendment Act of 2022. And next you have to know the Right of Children to Free and Compulsory Education Act. Right of Children to Free and Compulsory Education Act was passed by Parliament on 4th August 2009. And this particular act came into existence on April 1st, 2010. So, that's about right to education. So, Article 21A deals with right to education, and this particular article it declares that the state should provide free and compulsory education to children of age 6 to 14 years and this was introduced as per this 86th Amendment Act of 2022, and the president at that time was Dr. APJ Abdul Kalam, and the Prime Minister was AP Vajpayee. And you have to know the Right of Children to Free and Compulsory Education Act was passed by the Parliament 4th August 2009, and this particular act came into existence on April 1st, 2010. That's all about Article 21A. And we have mentioned that Article 14, 19 and 21, these three articles are considered to be considered as golden triangle. And you have to also understand that you have to also understand that the backbone of fundamental rights. Which article is mentioned as a backbone of fundamental rights? That is Article 19 is mentioned as a backbone of fundamental rights. Whereas which article is considered as the base of fundamental rights? That is Article 21 is considered as a base of fundamental rights. So that's all about Article 21A. And next we move to Article 22. Then Article 22. Article 22 means it deals with protection of arrest and detention in certain cases. Protection of arrest and detention in certain cases. That is Article 22 grants protection to persons who are arrested or detained. So it provides protection to persons who are arrested or detained. And this detention is of two types. It is punitive and preventive. And punitive detention, punitive and preventive. Here, punitive detention is to punish a person for an offence committed by him after trial and conviction in a court. And that is, punitive detention is to punish a person for an offence committed by him after trial and conviction in a court. And preventive detention means detention of a person without trial and conviction by a court. So, preventive detention's purpose is only to punish a person for a past offence, but to prevent him from committing offence in the near future. That is, preventive detention is only a precautionary measure and it's based on suspicion. So that is about Article 22, deals with protection of arrest and detention in certain cases. Here, two types of detention is there: punitive detention and preventive detention. And the preventive detention is only a precautionary measure and that is based on suspicion. So that's all what's mentioned in Article 22. And Article 23 to 24, it deals with right against exploitation. Article 23, 24 deals with right against exploitation. Here first Article 23, prohibition of traffic in human beings and forced labour. Prohibition of traffic in human beings and forced labour. Here prohibition of traffic in human beings. Traffic in human beings, the expression means selling and buying of men, women and children like goods. That is what's mentioned in prohibition of traffic in human beings. And the other thing is that prohibition is provided also where in human beings, as well as prohibition of traffic in human beings as well as forced labour. That is, no one should be forced to do such and such labour. So that is what explained Article 23, prohibition of traffic in human beings. That is, women should not be forced to do such and such labours, as also begging, etc. Then trafficking in human beings means include selling and buying of men and women and children like goods. That's what mentioned, that it should be prohibited according to this article. So Article 23 deals with the prohibition of traffic in human beings and forced labour. That is, no one should be forced to do such and such labours like begging, etc. And also then trafficking in human beings deals with selling and buying of men and women like goods. That is to be prohibited as per Article 23. Article 23 deals with the prohibition of trafficking in human beings and forced labour. Then Article 24, prohibition of employment of children in factories. Article 24 deals with the prohibition of employment in children in factories. That is, the prohibition of employment of children where even for those children who are below the age of 14, they should not be employed in any factories or mines or other hazardous activities like construction work, railways, etc. So that is to be prohibited according to Article 24. According to Article 24, prohibition of employment of children in factories, mines or other hazardous activities like construction work, railway, etc. Those children should not be below the age of 14. Those children should be below the age of 14 years should be prohibited from such employment. So they should not be employed in factories, mines, etc. That is what mentioned in Article 24. So these Article 23 and 24 deals right in exploitation. Where Article 23 deals that the prohibition of traffic in human beings and forced labor, and Article 24 declares the prohibition of employment of children in factories, mines, and other hazardous activities like construction work, railways, etc. That's what mentioned in Article 23 and 24. Next one, Article 25 to 28 deals the right to freedom of religion. Right to freedom of religion. That's what mentioned in Article 25 to 28. According as per Article 25, it says that all persons are equally entitled to freedom of conscience and right to freely process, practice and propagate religion. That means according to Article 25, everyone has the right to practice, to believe as well as practice and propagate their own religion. So that is what mentioned Article 25. Freedom of conscience, free profession, practice and propagation of religion. Then as per Article 26, freedom to manage religious affairs. That means freedom to manage religious affairs means that everyone has a right to establish as well as maintain institutions for religious as well as charitable purposes. Everyone has a right to establish as well as maintain institutions for religious as well as charitable purpose. That's what's mentioned in Article 26. In Article 27, freedom from payment of taxes for promotion of religion. So there no one should pay any type of tax for the promotion of their religion. So that deals with the freedom from payment of taxes for promotion of religion. That is, no religious institution shall be provided in an education should not provide any payment, or they should not be forced to pay such and such taxes for the promotion of their religion. That's what mentioned Article 27. That is freedom from payment of taxes for the promotion of religion. These are what related with Article 25 to 28. That means Article 25 to 28 deals with the right to freedom of religion, and here Article 25 declares that freedom of conscience, free profession, practice and propagation of religion, and Article 26 freedom to manage religious affairs, and Article 27 freedom from the payment of taxes for the promotion of religion. Then Article 28 declares that freedom from attending religious instruction. That is, as per under Article 28, no religious instruction shall be provided in any education institutions wholly maintained out of state funds. So those education institutions which are wholly maintained state funds, there should no religious instruction should be provided. So freedom from attending religious instruction is what mentioned in Article 28. So that's all about freedom of religion. According to article, that means as per Article 25 to 28, it deals with right to freedom of religion, where Article 25 declares that freedom of conscience, and free profession, practice and propagation of particular religion, and that is everyone has a right to believe, practice and propagate their own religion. And Article 26 declares that freedom to manage religious affairs. That is, everyone has a right to establish and administer institutions for religious as well as charitable purposes. And Article 27 deals with the freedom from payment of taxes, that for the promotion of any religion, no payment of tax, that is, no such payments of taxes are to be provided for the promotion of particular religion. And Article 28 deals with the freedom from attending religious institutions. That is, no religious instructions shall be provided in education institutions wholly maintained by state government, out of state funds. That means those education institutions wholly maintained out of state funds, they should not, no religious institution shall not be provided. So that is what's mentioned in Article 28, freedom from attending religious instructions. That is, those for education institutions wholly maintained out of state funds, there no religious instruction should be provided as per Article 20. So these are the articles which are mentioned in freedom for religion. So Article 25 to 28 deals with right to freedom of religion. Next one we are studying, moving to next one, that is Article 29 to 30. Article 29 to 30 deals with cultural and education rights. So, which article deals with freedom from attending religious instructions? That is, Article 28 deals with freedom from attending religious instruction. As per this article, no religious instruction shall be provided in any education institutions that wholly maintained out of state funds. Next, moving to Article 29, that is Article 29 to 30 deals with cultural and education rights. So here, this right is mainly mentioned. It provides that means it is according to this Article 29. This mainly deals with the protection of rights of minorities or interest of minorities. Protection of interest of minorities. Minorities in the sense means that is in Article 29 to 30 deals with cultural and educational rights. That means this right mainly deals with the protection of interest of minorities. Protection interest of minorities. Here minorities means both religious minorities as well as linguistic minorities. That means this particular article provides that any section of citizens residing in any part of India having a distinct language, script or culture of its own shall have the right to conserve the same. So, this particular article provides that any section of citizens residing in any part of India, those citizens having a distinct language, script or culture of its own, they shall have the right to conserve their language, script or culture of their culture. That is what's mentioned here. So, here culture and education rights, Article 29 to 30, first one, that is Article 29 means protection of interest of minorities. As per this section, any section of citizens residing in any part of India, those citizens having a distinct language, script or culture of their own, they shall have the right to conserve their language, script or culture. So that is what mentioned Article 29. And Article 30. Article 30 means that the right of minority to establish and administrate education institutions. A right of minorities to establish and administrate education institutions. As per Article 30, that means those minorities that is mentioned above, that is minorities, religious minorities or as well as linguistic minorities. They have the right to establish as well as administrate education institutions. That was mentioned in Article 30. So, Article 29 and 30 deals with cultural and educational rights. First one, 29 deals with protection of interest of minorities. Here, minorities refers to both religious minorities as well as linguistic minorities. And Article 29 provides that any section of citizens residing in any part of India having a distinct language, script or culture, they have the right to conserve their culture, language, script, etc. And Article 30, it deals with the right of minorities to establish as well as administrate education institutions. Those minorities means linguistic as well as religious minorities. That's what mentioned Article 29 and 30. And next one, moving to Article 32. Article 32. Article 32 deals the right to constitutional remedies. A right to constitutional remedies. That is, Article 32 confers the right to remedies for the enforcement of fundamental rights of an aggrieved citizen. So, Article 32 deals with the right to constitutional remedies. That Article 32, it confers a right to remedies for the enforcement of fundamental rights of an aggrieved citizens. In other words, the right to get the fundamental rights protected is in itself a fundamental right. So, the right to get the fundamental rights protected is a fundamental rights by itself. That is what mentioned Article 32. And see, if a person is not able to enjoy his fundamental right, he can seek remedy for that. According to this Article 32, he has the right to constitutional remedies. That is, he can approach High Court or Supreme Court for this remedy, and that that's what mentioned Article 32. And this Article 32, that means the right to get one's own fundamental rights protected, that is a fundamental rights itself. So this article is said to be a heart and soul of Indian Constitution by Dr. B.R. Ambedkar. So Dr. B.R. Ambedkar called Article 32 as a heart and soul of Indian Constitution because this right to get fundamental rights protected is in itself a fundamental right. So, and the article without this, the constitution will be a nullity. So that's why he mentioned it as a heart and soul of Indian constitution. As per this article 32, the Supreme Court has the right to issue orders for providing constitutional remedies, and these orders are known as writs. And as per High Court Article 30, as per the Article 226 of High Court, so High Court also have the right to issue orders, that is writs, again for the constitutional remedies. So that's what mentioned in Article 32 and Article 26. So Article 32, as per Article 32, Supreme Court has the right to issue orders or writs for the enforcement of these fundamental rights. That was mentioned in Article 32 and Article 226 of 220. As per Article 226, the High Court has the right to issue orders or writs for the enforcement of any fundamental rights. That was mentioned in Article 32. As per Article 32, Supreme Court had the right to issue orders or writs, and the writs are habeas corpus, mandamus, prohibition, quo warranto, and certiorari. And these writs, we shall study more about these writs in next class. So that's all about Article 32. So Article 32 means a right to constitutional remedies. That is, this article confers a right to get the fundamental rights protected, and that it is a fundamental right itself. So that right to get fundamental rights protected is a fundamental right itself, and so it's mentioned as heart and soul of Indian Constitution by Dr. B.R. Ambedkar. And as per Article 32, Supreme Court has a right to issue orders or writs for the enforcement of fundamental rights. And as per Article 226, High Court also has a right to issue orders or writs for the enforcement of the fundamental rights. That's all about Article 32. So in this class, we were discussing the remaining portion of the fundamental rights, and that's all more about all the fundamental rights are discussed in this class. So in the next class, we will be discussing more about writs related to the Supreme Court, that is habeas corpus, mandamus, etc. Those writs we will be mentioning those writs in next class. So hope you have all understood all those facts related to fundamental rights. So if this class is useful for you, please do subscribe my channel and wait for the further classes. Thank you.